Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, Illinois, you probably already know this, but your state government hates you. I know that. You certainly know that. And it appears now that they want to be able to attach their value to your life, and it appears that they know better about what you should be able to and not able to do as it relates to actually saving your life. And worse yet, they're willing to put all of that in writing. In America, if you think this is only Illinois' problem, trust me, it's just a matter of time before this type of craziness could actually end up on your doorstep as well. So today, let's spend a few minutes and let's talk about the most offensive argument used to disarm you. Okay, Illinois and America, we're going to talk about a case that we have talked about before, but it's really the argument that we're going to be focusing on. The case, of course, is Barnett v. Raoul. It is one of a dozen challenges or more to the Protect Illinois Communities Act, which, as you recall, was their assault weapon ban and magazine ban, which was really a piece of insurance legislation that got transitioned into an assault weapon ban and enacted all in about 72 hours, but I digress. Okay, now, this challenge, the plaintiffs here, those challenging the constitutionality of law, actually won at the lower level. Now, of course, it started getting ricocheting up around the Seventh Circuit, and that's when things went completely sideways. However, it comes before the Seventh Circuit Court of Appeals with the state of Illinois as the appellants. Okay, they are the ones that are appealing because on record right now, they have actually lost at the lower level. I want you to understand what the state of Illinois is arguing, because if you live in another state hell-bent on civilian disarmament, or a state that's just kicking that idea around, you better get used to these arguments, because the state of Illinois' argument as to why these laws have absolutely no constitutional deficiency at all goes like this. Number one, it's in common use for self-defense. Number two, arms that are more appropriate for military use are not protected. Three, any unnecessary item is unprotected. And number four, we get to make those determinations for you. So when you get into the opening brief that the state of Illinois has now filed in this matter, you will see exactly how the state of Illinois attempts to lay out this argument. Number one, we have to make sure that these weapons are super scary and are clearly only appropriate for military use. And how do they do it? Well, they do it like this. The items regulated by the Act are not protected arms for at least two reasons. First, none of them are arms because they are more like military-grade weaponry than weapons used for self-defense. Second, LCMs, assault weapons attachments, .50 caliber cartridges, and accessories used to increase the rate of fire of semi-automatic weapons are not arms because they are accoutrements that are unnecessary to operate firearms. All right, and then what they do is they go about just literally comparing everything humanly possible between what they believe is a military-grade weapon and what is marketed as a civilian weapon to say, look, they're exactly the same. Somehow or another believing that military-grade weapons, whatever the heck that really is, because again, that's as much of a made-up term as assault weapon, but believing that for some reason those are not protected. But this is the disingenuous way they go through trying to say that, hey, listen, the AR-15 and the M16, they're essential twins. The evidence presented below shows that the regulated items were initially designed for militaries or patterned after weapons designed for militaries, and that the modern civilian version of those instruments can be used nearly identically to how militaries use their firearms and accessories. You mean like you point them towards a target and then discharge the weapon? I mean, firearms really only have one universal use. Now, the state of Illinois continues this comparison, if you would, as follows. As this court preliminary recognized in Beavis, the semi-automatic AR-15 is almost the same gun as the M16 machine gun. The only meaningful distinction is that the AR-15 only has semi-automatic capability. And they continue this way. Indeed, AR-15s and M16s can be chambered with identical bullets, and the muzzle velocity, which is the speed a bullet leaves a firearm, of the two rifles are nearly identical when they are chambered with the same ammunition. Oh my God, did you guys know that two firearms with the same barrel length loaded with the same ammunition will have roughly the same velocity? God, who would have ever thought? And then of course there's this comparison. AR-15s and M16s also have identical ranges. Both AR-15s and M16s have a maximum effective range between 460 meters and 550 meters when chambered with the same ammunition. But they're not done there. Additionally, the accuracy and rate of fire of AR-15s and M16s are similar. As explained, M16s can fire in automatic or semi-automatic mode. It is undisputed that when M16s are used in semi-automatic mode, they have the same accuracy and rate of fire as AR-15s. And then, of course, while you're sitting there saying, hey, listen, M16s basically are AR-15s, what they're also making the argument is, hey, you basically can turn an AR-15 also into an M16. I'm not joking, okay, because this is what they wrote. There are devices and maneuvers available to increase the firing rate of semi-automatic weapons, with the result that any real-world difference in rate of fire between AR-15s and M16s is slight. Which, of course, then brings the state of Illinois to this conclusion. Finally, the similarity in ammunition, muzzle velocity, range, and firing and reloading rate means that wounds inflicted by AR-15s on civilians are identical to wounds inflicted by M16s on the battlefield. So the test is going to be that if the wounds are somewhat akin to what is seen on the battlefield, and whatever any of that means, I just want you to understand just how ridiculous these arguments are. But if the wounds are akin to what happened at the battlefield, then we can ban those weapons. And then when it comes to the AKs and the semi-automatic shotguns and the semi-automatic pistols that are all banned by this, what their argument essentially is, well, those two are all far more appropriate for military use and therefore not even protected by the Second Amendment. Okay, now that we've proven that these are really super, super scary firearms, more appropriate for our armed forces, now we must also establish that, well, you don't need any of this for self-defense. In fact, it's rather inappropriate for self-defense. According to who? Well, according to the state. The combat-ready features of the regulated items far exceed what is commonly used for self-defense. In addition to being suitable for military service, the items regulated by the Act far exceed what is needed for personal protection outside a war zone. Now, for those of you living in the south side of Chicago, maybe there's an exception for you because apparently they believe that maybe these are only necessary in war zones. I digress. The state further argues, especially when compared to handguns, the quintessential civilian self-defense weapon, the regulated items are poor choices for self-defense. So you see right there, the state gets to decide what the value of your life is by determining how you can and cannot preserve it. The state then also argues, as explained, the restricted weapons are designed to inflict enormous damage from significant distance. For example, AR-15s can reliably hit a human-sized target from 460 meters. This range is overkill for civilian self-defense encounters, most of which occur within 5 to 7 yards. So, the state is getting to determine ballistically what's most appropriate for self-defense. The state also wants to argue, furthermore, bullets fired by the restricted firearms carry a serious risk of over-penetrating walls and injuring innocent bystanders. This risk of over-penetration makes AR-15s unsuitable for individual self-defense scenarios where assailants are likely to be close by and neighbors or family members can be accidentally struck through walls. So, you don't need these for self-defense. Then, of course, we got to establish the third thing, which is anything that is actually not necessary to the core function of the firearm itself, we can ban, okay? Because you don't need it for the firearm to work, so we, the state, get to ban it because the state also argues LCMs also exceed what is useful for self-defense. The only evidence regarding the number of bullets an ordinary citizen uses for self-defense was from state defendants expert Lucy Allen. That's right, and then her report shows that it's only 2.2 shots. So we're going to let Miss Allen and the state of Illinois determine what your self-defense scenario is. By the way, it used to be 2.3 shots. I'm sure by the time I'm doing videos on it next year, it'll be down to like 1.8, whatever it may be. Eventually, you'll have a 3-round capacity ban. Moreover, LCMs are not necessary for the functioning of any weapon. Magazines are commercially available in many different sizes for the same firearm, and the larger capacity magazines regulated by the Act are just a subset of those available on the civilian market. Okay, so Illinois, this is what I want you and everyone in the country to understand, because these arguments could be coming your way as well. The state of Illinois, with a straight face, is actually arguing, one, the only arms that are protected are those that are in common use for self-defense. Two, arms that we believe are more appropriate for military use are not protected. Number three, any unnecessary items, as we see it, are unprotected. And four, we get to make all of these determinations for you. And in a long, long, long list of ways that they want to strip you of your constitutional rights, this, in fact, probably is the most offensive. Listen, special thanks to our good friend Greg Bishop out there in Illinois. He was kind enough to send me this opinion. If you're not checking out Bishop on air, you should. Link it up down below. If you guys got any questions about this or anything else related to what's left of our Second Amendment rights, Illinois, that's not much. You guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. Tell us by clicking on that link right there. If you want to subscribe to our monthly newsletter, the ability to do all of that's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Well, and just to give people the type of understanding of the financial catastrophic occurrence that occurred, you and I are both privy to people who have been involved in lawful self-defense situations, pulled the trigger with legal justification, faced potential legal consequences, and had to fight for their freedom. Didn't have coverage. How much money did it cost them to win their freedom?
You know, I really don't think that people really can grasp, you know, the magnitude of expenses. You know, most recently, and you and I have talked about this in the past, the Kyle Rittenhouse case brought a lot to light.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.